Today is Tuesday, February 10, 2015. Time is 10 a.m. It's my pleasure to call the order of the State of Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Ms. Lisa Mosley, will you please call the roll?
Mark Cawthorn.
Here.
Robert Helms.
Here.
David Neal.
Here.
W.T. Patterson. Jane Grace Sal. Robert Starkey.
Here.
Anita Taylor.
Here.
Mr. President, we have 6 of 7 members here.
Thank you, Ms. Mosley. We have a quorum. We'll continue the meeting as planned. We'll now adopt the agenda.
Move to adopt the agenda as presented, please.
Second.
Have a move from Sal, a second from Mr. Neal. All in favor?
Aye.
We will proceed. We'll call the meeting back in order. Next on our agenda would be to adoption of the Robert's Rules of Order for the board members for this year. I think there's been the current edition.
So moved.
Second.
Have a motion from Ms. Al, a second from Mr. Neal. All in favor?
Aye.
Okay. Has everyone signed their conflict of interest statements and give them back to Lisa? All right. The next on our agenda will be minutes. We'll review those.
Motion to accept.
Have a motion from Mr. Helms,
Second.
second from Ms. Taylor. All in favor?
Aye.
Motion carries. Now have our legal report from our staff attorney, Ms. Ellery Richardson.
All right, the first 2 cases before us today are case number 2014-022951 against funeral director and 2014-022952 against the funeral establishment. Respondent handled the arrangements for complainant's spouse. Complainant alleges that respondents held a funeral without her authorization, but upon the authorization of the deceased side of the family. Complainant originally authorized a visitation from 1 to 6 p.m. with a private funeral service to follow the next day. The deceased side of the family were not pleased with the private funeral service and wished to have a memorial service open to the public. Therefore, that side of the family planned to hold a memorial service at their church during the time of the visitation. The pastor of the church met with complainant the evening before the visitation and memorial service were to be held in an attempt to act as a mediator between the 2 sides of the family. He states the complainant was extremely upset, but he tried to get the family to reconcile their differences so there wouldn't be 2 separate services. At the meeting, complainant states that since the pastor was so insistent on wanting the funeral at his church, she agreed that he could have a scripture reading at the visitation. The pastor stated that he left the meeting under the impression that she had given him authorization to speak and have a small memorial service at the end of the visitation. He had gotten this authorization from one of complainant's sons after complainant had left the room. The pastor believed that the son had the authority to speak for the complainant. Based on that authorization, he told the funeral establishment of the plans and planned a small memorial service. Respondent states that she heard of the change to allow the memorial service through her office manager. Complainant called the office manager and told her that there would be a memorial service during the end of the visitation. Then, according to the respondent, complainant also asked if the casket could be moved from the visitation room to the chapel. The day of the visitation, complainant states that around 3 p.m., when she had already left the visitation, her family members called her to tell her that the other side of the family was planning on having a funeral. They had moved the casket from the visitation room to the chapel. People came in wearing funeral attire, and the other side of the family handed out programs they had created. The service had a full program with songs, none of which complainant said she'd authorized. Complainant's mother was at the visitation, and she states that respondent funeral director approached her and told her that she needed to leave because they were getting ready for a funeral service. Complainant's mother sat in the lobby for a while, but then sat through part of the memorial service. Respondent denies telling complainant's mother that she needed to leave. After some concerns that those coming to the visitation were confused because of the service and that they could not see the casket because of the service, the casket was moved back to the visitation room about halfway through this memorial service. Complainant was extremely upset that the funeral home was allowing a funeral service. She called respondent funeral director that evening, canceled the funeral service planned for the next day, and told respondent to bring the deceased to the cemetery along with a full refund. Respondent states that in that conversation, complainant told her that the funeral service was canceled, but she wanted to have a graveside service. Respondent staff brought the deceased to the cemetery at the scheduled time, but did not provide a refund. Respondent funeral home asked complainant if she still wanted the limousine. Complainant declined it, but respondent sent it to the cemetery anyway because complainant had already paid for it. Complainant states that respondent sent the empty limousine to make it appear that complainant and her family were riding in it. Respondent also had the military honor guard present as originally planned. Complainant dismissed them and did not accept the flag the honor guard presented to her. Complainant staff delivered flowers and other cash advance items to complainant's house. Respondent did not refund the $395 for the canceled repass or the $400 for the limo that complainant told respondent she did not want. There is an additional issue. The complainant requested respondent take pictures of the deceased before the body preparation, but she never received these pictures. Respondent stated the complainant did not sign a release for respondent to take pictures, but complainant states that respondent never mentioned needing to sign a release. My recommendation for this would be a consent order for $800 for not refunding the money paid for services that were canceled, and an authorization for a hearing.
That settle it?
If complainant wishes to take outside civil action, that is up to her. And
Your understanding that would,
my understanding is based on the violations that can be proven through our investigation, that seems to be fair. I know the complainant is, of course, extremely upset about this situation.
I move to accept recommendation of the attorney.
Second.
Have a motion from Ms. Sal, a second from Mr. Helms. All in favor? Motion carries.
Next case is case number 2014-022-981. Complainant is the daughter of the deceased who died on June 21st, 2014. Complaint alleges that respondent would not give the family the death certificate and told them that the death was being investigated by the coroner, and it may take 6 months to a year before the death certificate will be released. In September, complainant went to the coroner, who stated that there was no investigation and that the death certificate was released on June 30th. Respondent stated that the coroner released the death certificate on June 30th, and respondent promptly filed it. Because of a referral to the medical examiner, the health department did not approve the death certificate until July 31st. Respondent gave copies of the death certificate to the informant and purchaser. An investigation revealed that the physician signed the death certificate on June 30th, and respondent sent it to the health department on July 7th. The death certificate was flagged and sent to the medical examiner due to a vague cause of death. It was finally filed on July 31st. The health department gave complainant 2 copies of the death certificate. There are no prior complaints, and it took 16 days for the death certificate to be filed. As you can see, there's lots of issues with the health department. So my recommendation would just be to close with a letter of warning.
That recommendation of council.
Second.
Have a motion from Ms. Sal, a second from Mr. Neal. All in favor?
Aye.
Motion carries.
Case number 2014-025-061. A funeral board inspection revealed that respondent offered 7 caskets in its selection room that were not on the casket price list, and it offered 5 caskets at higher prices in its selection room than what is listed on the price list. Additionally, respondent did not have their current license available for inspection in its office. Respondent states that at the time of the inspection, the price lists were being revised. The new price lists are now available. Respondent informed the inspector that they had received new caskets that were not yet on their list and had put cards on the desk showing the prices of the new caskets. Respondent stated that it had renewed its license but had not received it from the department at the time of inspection. However, the renewal was April 23rd, and the inspection was not until June 17th. And there has been a similar violation in the past, and therefore my recommendation for this case would be a consent order with $250 civil penalty and authorization for a hearing.
Council's recommendation.
Second.
Have a motion from Ms. Taylor, a second from Mr. Neal. All in favor? Motion carries.
Next case is case number 2014-026711 against an apprentice, 2014-026712 against a funeral director, 2014-026713 against an embalmer, 2014-026714 against the establishment. A former employee of respondent number 8, the establishment, alleges that respondents filed a falsified transcript for the apprentice with the board by using the funeral director's school transcripts. Apprentice respondent states that she was granted an apprenticeship at the May 2013 board meeting. The high school she attended was a church-based school, and all documents were fully reviewed at the time the application was granted. Funeral director and embalmer respondent states that she had no part in falsifying any transcript. A board member of the school stated that the apprentice did graduate. An investigation did not reveal any evidence of a falsified transcript. Therefore, my recommendation would be to close the complaint.
Motion we accept. Second.
Have a motion from Mr. Neal, second from Mr. Helms. All in favor?
Aye.
Motion carries.
Next cases are against 4 separate establishments: 2014-027-371, 2014-027-431, 2014-027-501, and 2014-027-7771. Complaint filed by Rival Funeral Home against all 4 respondents over their pet crematories. Complainant alleges that when they were granted their license, the board told them that the pet crematory had to be completely separated from the funeral home. Complaint states that for these respondents, they advertised their pet crematory on the funeral home website and used the same office and phone numbers. Complainant does not think this is allowed based on his conversation with the board when the board granted his establishment license. If this is allowed, he wishes to do the same. And the rule is the fixed place of business rule, which I'll just state for the record. The board, in determining whether an applicant's proposed fixed place of business or establishment is devoted to the care and preparation of dead human bodies, may consider factors including but not limited to the following: any indication in the proposed establishment's name that suggests the establishment will be engaged in any activity other than the care and preparation of dead human bodies, and any evidence at the proposed place of business that suggests activity other than that incidental to the care and preparation of dead human bodies. And my recommendation would be to close with a letter of warning against all 4 of these respondents.
Motion to accept council's recommendation.
Second.
Have a motion from Ms. Taylor and a second from Mr. Helms. All in favor?
Aye.
Motion carries.
Next case involves that same fixed place of business rule, case number 2014-031141. The board staff received an anonymous complaint that stated that respondent sold its building to a church, and the funeral home leases the space when they need it for a service. The complaint attaches the church's website, which purports to show the church to be in the same building that the funeral home occupies. An investigation revealed that for the past 2 years, the church has leased space from respondent for its 2 services on Sunday mornings, one at 9 a.m. and one at noon, and sometimes on Tuesday evening for Bible study. The church has access to one of the chapels, the restroom facilities, foyer, and occasionally an office. The church president does have a key to the building. Respondent stated that if it has a funeral service scheduled, then the church would either meet in another area of the building or cancel its service for that day. The church does not have access to the locked preparation room or crematory facilities. My recommendation would be to close, but I'm not entirely sure how the board would handle interpretation of the rule in this situation.
Is this on a temporary basis or just,
It is,
I mean, we had for example, we have church that
Speak up.
Sunday mornings, so we allow them on a temporary basis.
This has been going on for 2 years, and it seems to be a permanent lease for the Sunday mornings, as long as
Are they renting them?
there is
or
a lease.
leasing the
There is a
space?
lease agreement, yes.
Well, it seems to be a violation. Not for the purpose that their establishment license was issued.
So basically, they're just holding funeral services.
The church has
the chur-
leased, has a lease agreement with the funeral home to use its chapel on Sundays, unless the funeral home has a service scheduled.
In your opinion, is there anything in state law that specifically says a funeral home cannot lease space?
The only law applicable that I've been able to find is the rule listed, the fixed place of business rule, and the rule is that the building must be devoted to the care and preparation of dead human bodies. But I know this is a more difficult issue, so it's how the board wants to interpret this rule to apply
When
to.
we did it, they used it for several weeks, our chapel for several weeks. There was no payment, there was no anything. But if it's a lease agreement or a rental agreement that indicates that there's a permanence to the relationship, then there appears to me to be a violation of the statute.
Right, the rule does say that.
Of course, it's a religious service, not like they opened a chapel's a chapel and they're having church. It's religious.
Right, it
Funerals
is-
are religious. I mean, if it was, I don't know.
The lease
doctor's
is with the
office or something.
church, and of course, I'm not sure for certain, but I don't know of any relationship between the establishment, the managers, and I do not know that they're members of that church. Doesn't seem to be any relationship like that. Just a church approached them, or I'm not entirely sure how it came about, but there is a lease with this church. The funeral home, to my understanding, does not advertise that it is also the location of a church, but the church does advertise that its services are at this location.
And basically, all the funeral home does is use the facility whenever they need whenever they're having a funeral service, and that's it.
Sorry, state that again?
The funeral home only uses the church building when they have a funeral service. Is that correct?
It's the funeral.
So
It's the funeral
The
building's
church is the
chapel
one
that
that
the church
the
uses.
building, the funeral home sold their building to a church.
No, they did not. The complaint alleged that
That's what it
it
says.
was
That's what
sold.
it says. Okay, that's
All
why
right,
I'm
sorry.
getting
I'm sorry if
confused.
that was confusing. The complaint alleges that the building was sold. That is not correct. The funeral establishment still owns the building, but they
Okay.
lease the chapel and certain other rooms to the
To
church.
the church, okay, it's backwards, okay.
Yes, I apologize for the
okay,
confusion on that.
Okay, I got you.
There was one in Camden that they, model, and this funeral home had 2 chapels. And, they just,
But that's what I was saying we did,
and they did, I don't know.
but we didn't charge them anything.
This is
for it.
never ending. This is going to be never ending. Is what you're saying.
It
If you
seems
get
to
a
be a
lease agreement,
permanent
it's
situation.
gonna be-
But I asked if it was a
It's been going on
permanent
for
situation.
about 2 years.
So basically, all the funeral home is doing is letting the church use the chapel for a church service.
Yes, for, I
Oh,
think it's about $400 a month
Oh.
that they get.
Of course, it's not competing during funeral times. This is during Sunday mornings or
Right.
Tuesday, so it's not taking away their function from being a funeral home.
Right, and respondent has said if anyone wishes to have a service on Sunday, the church is very accommodating, either cancels their services or goes to a different room.
Make a motion, we accept council's recommendation.
Second.
For Mr. Ham, second for Mr. Neal, all in favor? Aye. Motion carries.
Tell them they need to let them use it for nothing and take it as a tax deduction, and then they're in compliance.
Yeah. All right, the next case is case number 2014-028-531. Respondent manager allowed her funeral director's license to expire on June 30th and did not renew it until July 16th. Respondent establishment handled 3 cases during this time period, and respondent did not respond to the complaint. And then the violations are listed. And then my recommendation would be a consent order for a $400 civil penalty and authorization for a hearing.
Accept council's recommendation.
And in that, you've already got where they didn't respond. It's
Yes.
included in that. Is that correct? Okay.
Okay. Second.
Have a motion from Ms. Taylor, a second from Ms. Sal. All in favor?
Aye.
Motion carries.
The next case is case number 2014-028-571. Respondent's establishment license expired on June 30th and was not renewed until July 3rd. Respondent handled 1 visitation. Respondent apologizes for the oversight. And since they have had a similar violation in the past, my recommendation, would be a consent order for $250 civil penalty and authorization for a hearing.
Motion to accept.
Second.
Have a motion from Mr. Helms, a second from Mr. Patterson and Ms. Taylor. All in favor?
Aye.
Motion carries.
Next case is 2 separate funeral establishments, but they're just separate location. They're all owned by the same people. That's why they're grouped together. It is case number 2014-028-591 and 2014-028-581. Respondent signs do not have the full name of the funeral establishments. In response, respondent states that the signs have been removed. However, the board inspector gave respondent warnings for the same issue back in 2012. And therefore, my recommendation would be a consent order with civil penalty of $250 and authorization for a hearing for each establishment.
So now, after the warnings in 2012, they have not complied until recently.
Right, when the inspector returned in 2014, the signs had not been changed.
And that was all under the new ownership?
Yes.
2 years.
That's correct.
New ownership was when?
It was right around 2008, 2009. Sorry, I just did that because there is other history before that, but it was under the prior owner, so I didn't believe it was relevant.
The current owners were the ones given the warning.
Yes, that is correct.
All right.
And this is just kind of showing my ignorance on this part, but what does the law state about having to have the full name of the?
Yeah, there's a rule 0660-1-.03. All advertisements must have the full name of the funeral establishment as it is licensed by the board. And I recommended disciplinary action in this case because they have been given a warning 2 years ago and they still haven't complied.
This is for each establishment?
Yes.
Motion to accept council's recommendation.
Second.
Have a motion from Ms. Taylor and a second from Mr. Neal. All in favor?
Aye.
Motion carries.
All right, the next case is case number 2014-028831. Respondent's establishment license expired on July 31st and was not renewed until August 18th. Respondent handled 8 services during this period. The establishment was sold to the current owners on September 25th, which was after the period of this lapse. And the former owners did respond apologizing for the oversight. So my recommendation would be to close with a letter of warning so the new owners will know not to do this.
Motion to
What
accept.
about the respondent that was in violation?
Well, we
Do they
take
still have-
action,
Do they still have a license?
not for this establishment. I'm unsure. I do believe they have other establishments, but the disciplinary action would be against this license, and they no longer own this license.
Motion to accept.
Second.
Have a motion from Mr. Helms, a second from Ms. Taylor. All in favor?
Aye.
Aye.
Motion carries.
Next is case number 2014-029-321. Complainant alleges discrimination. He states that he is 72 years old and incarcerated in Tennessee. He wrote to Respondent Funeral Home about planning his arrangements because Respondent handled his parents' and grandmother's funerals. Respondent never responded to complainant's 3 different letters. Complainant mentioned this to a friend in town, and the friend called Respondent on her own without authorization from the complainant. Respondent then wrote to complainant asking that he tell his friend his plans so Respondent can prearrange the funeral through the friend. The friend is not a relative. Complainant responded to Respondent's letter saying that he wanted to work with the funeral establishment, not through a third party. Respondent then went to the cemetery and told the friend some information to pass along to complainant. Respondent never contacted complainant again. Complainant made his arrangements with another funeral establishment. Respondent is upset the complainant ignored him, believes that ignoring people is not an acceptable business practice, and wishes for an apology. Respondent states that she did not get the 3 letters, and the first she heard of the complainant was when his friend called Respondent. The friend gave Respondent complainant's address. Since his first interaction was through the friend, Respondent assumed that complainant, was satisfied with communicating through her. There's no prior history. My recommendation would be to close.
Motion to accept council's recommendation.
Second.
Have a motion from Mr. Cochran and a second from Ms. Taylor. All in favor?
Aye.
Motion carries.
I have 2 cases to represent before you. The first one is 2010008611. This case is currently in litigation monitoring status. The complainant alleged that she received the wrong person's cremains. And for Board Member Cochran, sometimes when there's a civil complaint going on or civil litigation going on, we hold the complaint pending outcome. And that's what litigation monitoring is. And so we received notification that the civil case was settled. After multiple attempts, the department has been unable to contact the complainant. Without the complainant, the department does not have enough evidence to move forward with the allegations. So my recommendation would be to close the complaint.
Motion to accept.
Second.
Have a motion from Mr. Helms, a second from Mr. Patterson. All in favor?
Aye.
Motion carries.
The last case before you today is case number 2011004472. Against the funeral director, complaint arose from a failure to pay a transportation company for transporting remains from Florida to Tennessee. After initiation of the complaint, respondent paid complainant in full. The board originally authorized a $1,000 civil penalty, but since that authorization, the money has been paid and the funeral establishment connected to this complaint has since closed. So therefore, my recommendation would be to reduce the civil penalty to $250 against the funeral director.
Move to accept recommendation of council.
Second.
Have a motion from Ms. Sowell, a second from Mr. Neal. All in favor?
Aye.
Motion carries.
That is the end of my legal report.
Thank you, Ms. Richardson. Next on our agenda will be administrative matters. Mr. Robert Gribble, Executive Director.
Thank you, Mr. President. First item I want to mention to the board is a monthly meeting that I have with the accounting manager in the Assistant Commissioner's office. For the board members that were on the board last year, you'll recall that the Assistant Commissioner appeared before the board and talked about the budget and the expenses and revenue of the board and things of that nature. And probably next month, the Deputy Commissioner and the Assistant Commissioner will be back. We have a new Assistant Commissioner, Brian McCormick, and the Bill Giannini, who was the Assistant Commissioner at the time he appeared before the board last year, is now the Deputy Commissioner. So they will probably be here at next month's meeting. But I want to report to you that I do meet on a monthly basis with the accounting manager of the Assistant Commissioner's office. We look at the board revenues, we look at the expenses, we look at the license are issued, the time frames that they're issued on. It's basically a financial review of all matters pertaining, to the board office. And for Board Member Cochran's information, each board is required to be self-sufficient. And our board, most of our licenses the funeral directors, embalmers, and funeral establishments renew on the June the 30th of the even years. So this year will be a down year for us, and typically our expenses are more than our revenue in the odd years. But we have a reserve that takes care of the even years. The revenue is much more than the expenses, so we have a good reserve. And so that you know this, the board reduced the renewal fees back earlier, less than a year ago. The funeral director and embalmer renewal fees were $275 every 2 years, and the board, because of a reserve, was able to reduce that to $235. So financially, we're in good shape, and I just want to mention to you that we do look at that on a monthly basis. And anytime you have any questions other than what we present to you, or in addition to what we present to you, never hesitate to let us know. We're certainly available to answer whatever questions you have about any financial matters of the board. The licensee report. You have a report of licenses that have been administratively approved by the executive director pursuant to the board's authority for the period of December 9, 2014 through February 8, 2015. You have the establishments and the individuals. Closed establishment report. There were 3 establishments that have reported closing since the last board meeting. That was Curry Funeral Home at 416 Sampson Avenue North in Dyersburg, Irwin Memorial Funeral Home Incorporated at 1015 North Main Avenue in Irwin, Tennessee, and Harrison's Funeral Home, their Orange Mound Chapel, which is located at 2647 Carnes Avenue in Memphis. Disciplinary action report. This is a report of consent orders administratively accepted or approved by the executive director pursuant to the board authority for the period of December 1, 2014 through January 31, 2015. And month, that's the list of disciplinary action taken by the board for the months of December and January. Last item I have is a complaint report for this meeting. As of yesterday, there were a total of 61 complaints, 1 against an apprentice, 12 against funeral directors and/or embalmers, and 48 against funeral establishments. Mr. President, that's my report concerning. I have another matter, but it's listed separately. So that's my director's report.
All right, thank you, Mr. Gribble. Next, we'll have your legislative update.
Motion
Excuse me.
accept.
Have a motion to accept his report.
Make a motion.
Have a motion from Mr. Neal and a
Second.
second from
Ms. Taylor.
Ms. Taylor. All in favor?
Aye.
Motion carries. Next on the agenda will be the legislative update.
Mr. President, at each meeting, we want to make you aware of bills that are going through the legislature, have been introduced. And so for this report, we have Senate Bill 0194 and House Bill 0163. Those are companion bills, asterisk beside the House bill, and that's what we call the main bill. Sometimes it'll be the Senate bill and sometimes the House bill. But this bill has to do with funeral directors and embalmers. As introduced, it clarifies that 2 members of the Board of Funeral Directors and Embalmers with a minimum of 5 consecutive years' experience in the state immediately preceding their appointment shall be licensed as funeral directors, embalmers, or both, and provides that if the board is inspecting a crematory facility in conjunction with an application for initial licensure, change of ownership, or change of location, the authorized representative from the board conducting the inspection shall also be certified as a crematory operator. This amends TCA Title 62, Chapter 5, Part 2. If you wanted to look at the bill, that's the link there that would take you to that bill. I'll go over all of these, and then if you have any questions about any of them, I'll be glad to answer them. Next is Senate Bill 0320 and House Bill 0289, which are companion bills. This has to do with autopsies, and as introduced, rewrites the Postmortem Examinations Act effective January 1, 2017. It requires counties to appoint a medico-legal death investigator and terminates the Tennessee Medical Examiner Advisory Council. It amends TCA Title 4, Chapter 29, Part 2, Title 38, Chapter 7, and Title 68, Chapter 1, and Part 11. Also the link there. And you might ask, well, why did I make the board aware of that? Well, it's 16 or 17 pages. I read through the whole bill. It mentions the word, now it uses all these modern phrases for the medical examiner and all those people, but when it gets to the people in our line of work, it refers to them as an undertaker. So I don't know why, but it does. But the word undertaker is mentioned in that bill.
What's behind that?
Well, it's a
What's
whole new,
behind the bill?
it's a whole new system for a medical examiner's system in state Tennessee. And I don't have enough knowledge to, I do not.
If you follow the link,
Genre of
it
the
will-
origin, is this from the medical community, or is this from?
I have no idea, Miss Sal.
Yeah, if you follow the link, it will say which House member or Senate member introduced the bill. I think that's all the information. Yeah,
Henry, but that doesn't always tell you.
yes,
that.
I know. I'm unsure of the answer to your question.
And there's one other sentence in that bill that applies to funeral directors, embalmers, and funeral establishments. And it says, "No body subject to postmortem examination as provided in this part shall be embalmed without approval by a postmortem official." So in reading that 16 or 17 pages, those are the only two things that I could find applicable. The word undertaker and the sentence that I just read.
Mean to you that every deceased body is, that we have to contact the medical examiner prior to embalming, even though we have the authorization from the next of kin?
No.
That's not what that means.
No, it lays
Okay.
out several scenarios where a person would, but it doesn't entail every death. It doesn't require you on every
But
death.
it's specified when it takes effect.
And it specifies several scenarios of what the death would be resulting from or what they think the death might result from when you would contact them.
It's not as a general rule.
Not on every death is the way I understand it. But again, it's not a bill that directly affects this board, but it is something I feel like it probably as funeral directors and embalmers you'd want to be aware of. And then there's House Bill 0199. It does not have a Senate bill, companion bill yet. And it has to do with insurance companies, agents, brokers, policies, and introduced, finds funeral merchandise for prearrangement insurance policy, amends TCA Title 46, Title 62, Chapter 5. And there's a link for legislative bill searches that you can search by bill number, or you can simply go there and type in funeral or pre-need, funeral contract, whatever you want to. This morning, just prior to coming down to the board meeting and after everything was already set on your iPads, we were made aware of one other bill, House Bill 0446, and it has to do not directly with this board, but it has to do with something that the board deals with. It's cemeteries, as introduced, makes various changes with regard to the treatment of urn vaults, out-of-barrel containers, and other merchandise offered by cemetery company in pre-need contracts and in the disbursement of trust assets. It clarifies the law applicable to pre-need contracts offered by cemetery companies. It amends TCA Title 46 in Chapter 1.
And that's House Bill what?
House Bill 0446.
Would that concern how much money will go into trust in those instances, or does it?
Well, it defines merchandise in Title 46, which is the title that regulates cemeteries.
Go on the state government website and look up every bit of this, and it's
Has to do with when the money would be put into trust. Says that nothing in this part applies to contracts for the sale of funeral merchandise and services. And contracts for the sale of funeral merchandise and services shall be regulated under Title 62, Chapter 5, and other general laws of the state. And Says that contracts for sale of merchandise as described in this part shall be subject only to the requirements of this part, not Title 62, Chapter 5. So what that's saying is merchandise is defined as any personal property sold on an at-need or on a pre-need or at-need basis by a cemetery company, including but not limited to foundations, markers, memorials, memorial bases, monuments, urns, urn vaults, outer burial containers, grave boxes, grave liners, vases, lawn crypts, and mausoleum crypts. President, that's the information I have about bills that are that have been filed and introduced at this time, and we believe it to be true, accurate, and correct up to as late as this morning. But as far as knowing if something else has been introduced today, we don't know. The filing deadline is nearing, so if any more bills are going to be introduced, they'll probably be done in the next few days.
Thank you, Mr. Grable. We would not need a motion to, of that report.
Make you aware in case
Okay.
you want to take any action as a board, or in case you want to do something, just so you're aware of it.
Next on our agenda will be approval of license applications.
First person is Trudy Ann Riggs. Ms. Riggs, if you're present, if you would, please come up to the table. She is from Hendersonville. This applicant is seeking licensure as a funeral director and embalmer by reciprocity from Alabama. I could have administratively, pursuant to your authority, approved her funeral director's license. The only question has to do with their embalmer's license. It appears from the information that we know that it's appropriate, but Ms. Riggs, if you want to introduce yourself and tell the board about your history as far as your license, your embalmer part, and they may have some questions for you.
Okay, my name is Trudy Ann Riggs, and I have been licensed in the state of Alabama for the last 15 years. I had the privilege of working for the majority of that time, and at some point in time, is about 2006, I had the opportunity to purchase that funeral home with a partner, and we had a conflict of personality, so we separated ways. I've always maintained my license there, and I've worked there until 2012, and from 2012 to 2014, I worked for a funeral home on the coast of adjoining Alabama, and that's pretty much it. I've always been in the business, and I've had a license in good standing for. Sorry. Oh, sorry.
There was an embalming issue?
With her embalmer's license, she has an associate's degree. She's passed the national board, the arts part. She has not passed the science part of the national board, but she hasn't taken the science part of the national board from what she told me yesterday. When she first became licensed, she can tell you the story better than I can, but as I recall from our conversation yesterday, she was licensed in the state of Alabama through their probably state examination at the time. But she meets the period of time, you know, and maybe I could have approved that embalmer part as well, Ms. Taylor, but if there's ever a question or it's in the gray, we always come to the board and let the board make a decision.
All right, in Tennessee.
I'm working for Spring Hill Funeral Home and Cemetery in Nashville, on the outskirts of Madison. I've been with them for 2 weeks, and I'm learning quite a few things from some new people.
Explain to me again the issue.
Just
The
out of
state test in Alabama is correct, and she did not take the national board.
Yeah.
Passed the
But-
state test in Alabama
Yes, but she
on
has
both parts.
She has a associate's degree, and she has passed the national board test as far
I
as the
thought I
arts
saw
part.
that in here.
Yeah. You know, I would recommend approval, but I did not want to do it administratively because it's somewhat in a gray area, And I just,
What is the gray area? I missed it.
well,
And there are two parts to the national test, is that what you said?
yeah.
Yeah, there are two parts to the national test, and she only took one of them.
You only took which part?
I took the arts part in 2012 of the national board, but I've been state licensed in Alabama, both funeral director and embalmer. Funeral director for 17 years and embalmer for 15.
Embalming part of the national board?
Only the arts part of the national board.
Of course, you're not required to pass the national board to be licensed in the state of Tennessee, so she does meet all her requirements, I think.
Second.
Have a motion from Mr. Patterson, a second from Mr. Neal. All in favor?
Aye.
Motion carries. Thank you.
Congratulations.
On the establishments, you have one establishment, Cremation Society of Tennessee LLC, which has an application to move to 2014 Elmer Pug Drive, Suite 102 in Columbia, Tennessee. It's a change of location. Ownership's a limited liability company, and the owners are Cremation Society of Tennessee LLC, which is located in Columbia, Tennessee. Will introduce yourselves for the record, please.
My name is Benjamin Curtis. I'm the acting manager at the Cremation Society of Tennessee. What we're trying to do is just change locations. It's really just a couple miles down the road, but it's financial decision. The current landlord that we're at has fluctuated in prices. We found a more locked-in rate at a new facility that we would like to get in.
Mr. President, I recuse myself from consideration of this matter.
All right. I notice on your funeral packages, and maybe I'm just kind of in the gray area here. Can you of course, I know a cremation society has a funeral home license, but you do not have to say, I'm asking you, Mr. Gribble, point this question, when you have funeral packages, you don't have to have an burial or anything. In other words, it's just Cremation Society of Tennessee can offer funeral packages. As long as you offer it on your general price list, I presume that's legal.
I see no reason why it's not.
Okay.
Unless council knows some other
So
reason.
the
You
question
have a
was,
license to do either one.
so just so I'm clear, the question was about packages? Could you restate your question?
Well, no, it just had funeral packages and cremation packages, but it's just Cremation Society of Tennessee. So
I think-
I would say as long as you have it on your general price list, you could do it, probably.
To me, it would be the same difference if a funeral home is offering cremation services. You know, the name of the establishment's ABC Funeral Home, it can offer cremation services. So if the name of the establishment is Cremation Society and they offer funeral services.
Right,
then-
as long as it's on the price list, there shouldn't be a problem.
There's an email from the field rep dated December the 5th, field representative who did the inspection. And he goes into detail as to what he did and what he found and things of that nature. That was not one of the things he mentioned.
I think all we're dealing with really is just a change of location. It's a firm that's been duly
Make a motion to approve.
Second.
Have a motion from Mr. Helms, a second from Mr. Neal. All in favor?
Aye.
Motion carries. Right. Do we have any new business to come before the board? No new business? Do I have a motion to adjournment?
So moved.
Have a motion from everybody for adjournment. All in favor?
Aye.
Motion carries. Thank you very much.